Every year in Brazil, a heated debate reignites around the saída, a temporary leave granted to certain inmates, allowing them to visit family during major holidays like Christmas, Mother's Day, and Easter. This policy, officially called saída temporária, is designed to support the gradual reintegration of prisoners into society, giving them a chance to reconnect with loved ones and experience life outside prison walls, if only for a few days. While some see it as a humane measure, others argue it's too lenient and potentially risky. Recently, the spotlight has shifted to former President Jair Bolsonaro, who is currently in preventive custody. Speculation has swirled in the media and on social networks. Could Bolsonaro, like other inmates, be eligible for a Christmas saída? The question has sparked confusion and controversy, with many people unsure about the legal realities. The answer, however, is a clear and unequivocal no. This isn't a matter of political opinion or public sentiment. It's rooted in established Brazilian law. The rules governing saída are strict, and they apply equally to all, regardless of status or notoriety. Let's break down the three main legal barriers that make Bolsonaro ineligible. First, he is a provisional or preventive prisoner. This means he hasn't been convicted and sentenced yet, but is being held while awaiting trial, a status that automatically excludes him from temporary leave programs. Second, the law requires that inmates must have already served part of their sentence and demonstrated good behavior. Since Bolsonaro has not been convicted or served any sentence, he does not meet this fundamental requirement. Third, a recent amendment to the law has made eligibility for saída even more restrictive, further closing the door on cases like his. These changes were enacted to address public concerns and tighten the criteria for temporary leave. By examining these legal points, it becomes clear that Bolsonaro's saída was never a real legal possibility. The law is explicit, and no amount of speculation can change these facts. To understand Bolsonaro's case, we need to look at Brazil's law of penal execution, or LAP, which governs inmate rights and benefits. The saída is not a pardon, but a tool for resocialization, detailed in Articles 122-125. Only inmates in a semi-open regime, with good behavior and a minimum portion of their sentence served, can qualify. The law is strict. Temporary leave is earned, not automatic. Provisional prisoners, those awaiting trial, are excluded from these benefits. This structure makes it clear why discussing saída for Bolsonaro is legally misplaced. Bolsonaro's biggest obstacle is his status as a provisional prisoner. In Brazil, only convicted inmates serving a sentence can access saída. Provisional prisoners, presumed innocent and awaiting trial, cannot. Bolsonaro is in preventive detention, a measure to protect investigations, not a punishment. Article 122 of the LEP is explicit. Only convicts in a semi-open regime are eligible. This rule applies to anyone in preventive custody, regardless of their profile. As long as Bolsonaro remains unconvicted, the saída is off the table. The law is clear. No conviction, no benefit. Even if Bolsonaro were convicted, he'd face another hurdle, serving a minimum portion of his sentence. The LEP requires inmates to serve at least 1/6 first-time offenders or 1/4 repeat offenders of their sentence before qualifying for saída. Bolsonaro has no conviction, so he has no sentence served, making him ineligible. This rule ensures only those progressing through rehabilitation can access temporary leave. Without a conviction and time served, eligibility is impossible. In 2024, Brazil took a significant step in its criminal justice system with the introduction of Law No. 14843. This new legislation, passed in April, has brought about some of the strictest changes to the country's prison regulations in recent years, especially regarding temporary prison leave, known as saída. The law was designed to address growing public concern over crime and to tighten the rules for inmates seeking temporary release. Under the new law, inmates convicted of heinous crimes or those involving serious violence or threats are now categorically barred from receiving saída to visit their families. This marks a dramatic shift from previous policies, which allowed even those convicted of serious offenses to apply for temporary leave under certain conditions. The intention is clear: to prioritize public safety and send a strong message about the consequences of violent crime. Interestingly, President Lula initially vetoed this particular provision, expressing concerns about its fairness and potential impact on rehabilitation. However, the Brazilian Congress, reflecting the prevailing tough-on-crime sentiment, overrode his veto. This rare move by lawmakers ensured that the restriction became law, highlighting the political will to enforce stricter penalties. For former President Jair Bolsonaro, this new law could have personal consequences. The crimes he is currently accused of, such as attempting a coup and other acts considered grave threats to democracy, fall squarely within the categories targeted by Law 14-843. If convicted, he would be subject to these new, harsher restrictions. Even if Bolsonaro were to serve time and meet other requirements, the law would likely block his eligibility for saída, closing off a path that was previously available to many inmates regardless of their status or notoriety. There's a certain irony here. The law, which aligns closely with Bolsonaro's own tough-on-crime rhetoric and policies during his presidency, now stands as a potential obstacle for him personally. It's a striking example of how legal reforms can have unexpected and far-reaching effects, even for those who once championed them. With these sweeping changes, the path to saída is now closed on multiple fronts, signaling a new era in Brazil's approach to crime, punishment, and justice. The nature of the accusations against Bolsonaro, plotting to overturn election results and threaten democracy, falls under crimes of grave threat. These offenses, by law, are treated as heinous or equivalent, triggering the strictest restrictions. The new law explicitly bars saída for such crimes, even if violence was only threatened, not carried out. Legal experts agree a conviction for these acts would permanently block Bolsonaro from temporary leave. The very laws he supported now ensure his ineligibility. Brazil's approach to temporary leave mirrors global standards: strict eligibility only for low-risk convicted inmates. In countries like Germany, Canada, and the UK, pre-trial detainees or those accused of serious crimes are never granted such benefits. High-profile cases in Brazil, like those from the Lava Jato operation, followed the same rules: no saída before conviction and time served. This consistency upholds equality before the law, regardless of status. The rules that apply to Bolsonaro apply to all. The spotlight on his case simply highlights the system's established procedures. The strict application of the LEP, or Law of Penal Execution in Bolsonaro's case, sends a powerful message about the strength and impartiality of Brazil's legal system. By holding even a former president accountable to the same standards as any other citizen, the judiciary demonstrates that the rule of law is not just a principle, but a practice that applies to everyone, regardless of status or influence. This reinforces the idea that no individual, no matter how prominent, is above the law. The public can see that justice is not selective and that the legal process is designed to be fair and transparent for all. The case also brings clarity to the distinction between preventive detention and actual punishment. Preventive detention is not a form of retribution, but a necessary measure to ensure the integrity of investigations and the safety of society. By making these differences clear, the legal system helps educate the public, dispelling myths and reducing the spread of misinformation about how justice is served in high-profile cases. The outcome of this case sets a significant precedent for future investigations involving influential figures. It shows that the same legal hurdles and procedures apply, regardless of a person's political or social standing. This means that all high-profile individuals, whether in politics, business, or other sectors, must face the same rigorous legal process and cannot expect special treatment. The recent changes in the law also send a strong signal that any attack on democratic institutions will be met with the strictest legal consequences. These are not just symbolic gestures, but real restrictions that affect both sentencing and the possibility of receiving prison benefits. Those found guilty of undermining democracy will face not only longer sentences, but also fewer privileges while incarcerated, making the consequences of such actions much more severe. Ultimately, these developments serve to strengthen Brazil's democratic protections and reinforce the independence of its judiciary. The message is unmistakable. In Brazil, it is the legal rules and the constitution, not political power or personal connections, that determine the outcome of justice. In summary, Bolsonaro's ineligibility for the saída is rooted in law, not politics. 3 barriers: provisional status, no time served, and the new law, each independently block his eligibility. These rules have long applied to all inmates, regardless of fame or office. The recent legislative change only reinforces this. The case is a lesson in the primacy of law over political narrative. In Brazil, the justice system's foundation is clear, consistent, and impartial application of the law.